This is the essay review of agency and partnership. Looking at liability of the principal for the tort of the agent. The rule is that the principal is liable if the principal-agent relationship exists and the tort was committed by the agent within the scope of the principal-agent relationship. Now, looking at the principal-agent relationship, we have to look at ABC, assent, benefit, and control. Assent is voluntary, informal agreement. The principal must have capacity. The benefit is the agent's conduct must be for the principal's benefit. And control, the principal must have a right to control the agent by having supervisory power. If there is no assent, benefit, and control, such as with subagents or borrowed agents, there is no vicarious liability. In regards to independent contractors, there's no vicarious liability because there is no power to supervise performance. Now, looking at the scope of the agreement, because again, the principal is liable for torts committed by the agent within the scope of the principal-agent relationship. Now you have to ask the question, was the conduct by the agent the kind the agent was hired to perform? Did the tort occur on the job? Did the agent intend to benefit the principal? Part of the analysis is looking at a Frolic versus a Detour, whether the tort was committed on the job. A Frolic is a new and independent journey, and this is outside the scope of the principal-agent relationship. A Detour is a mere departure from an assigned task, and this is within the scope of the principal-agent liability. Looking at a principal-agent relationship and liability of the principal for torts of the agent and intentional torts, they are generally outside the scope of vicarious liability, except where it's specifically authorized by the principal or it's natural from that type of employment, such as a bouncer at a bar. Looking at liability of principal for contracts entered by the agent. The rule is that the principal is liable for contracts entered into by the agent if the principal authorized the agent to enter into the contract. So, does the agent have authority? Looking at types of authority, you have actual express authority, actual implied authority, and apparent authority. Actual express authority is where the principal used words, including oral or written agreement, to express authority to the agent. Here you can consider the equal dignity doctrine. If the contract entered into by the agent must be in writing, then the express authority granted to the agent must also be in writing. So that's actual express authority. Actual implied authority is authority which the agent reasonably believes the principal has given the agent because of necessity in order for the agent to accomplish assigned tasks, or by the custom of the trade, or by the agent's prior dealings with the principal. Looking at authority and apparent authority, this is where the principal cloaked the agent with an appearance of authority, and a third party reasonably relied on the appearance of authority. Under apparent authority, you can have lingering authority. This is where actual authority has been terminated, but the agent continues to act on the principal's behalf. Here, the principal is still liable until the customer receives notice of termination of the authority. Continuing with liability of principal for contracts entered by the agent and looking at ratification, the principal is liable where the contract has been ratified. This is where the principal has knowledge of all material facts regarding the contract and the principal has accepted the benefits of the contract. Ratification may occur where the principal has granted authority after the agent entered into the contract. So the agent enters into the contract on behalf of the principal without authority. Principal then grants authority. Principal then has knowledge of all material facts regarding the contract, accepts the benefits of the contract. The principal has then ratified that contract and will be liable for that contract. Now, ratification in this context must be completed as is, no alterations to the terms. Now, extent of the liability, if there is no authority, the principal has not granted any authority to the agent, the principal is not liable, only the agent is liable. If there is authority, so the principal has granted authority to the agent, the principal is liable, the agent is not liable. Looking at duties the agent owes to the principal, they owe duty of reasonable care, to obey reasonable instructions, and the duty of loyalty. And the duty of loyalty is the agent can have no self-dealing, cannot get a benefit to the detriment of the principal, and no usurpation of principal's opportunities, no secret profits. Looking at partnership and a general partnership formation. So moving on from agency-principal relationship, looking at general partnership formation. Here there are no formalities. The general partnership can arise out of conduct. A general partnership is an association of two or more people simply carrying on as co-owners of a business for profit. Now, the sharing of profits creates a presumption of a general partnership. Moving on to liabilities of partners to third parties. Generally, agency principles apply with regards to torts and contracts. We discussed that previously. Looking at liabilities of partners to third parties and personal liability for debts of the partnership, where you have an incoming partner or a dissociating partner, the liability might be different. An incoming partner is not liable for pre-existing debt, but funds from an incoming payment can be used to satisfy prior debt. So an incoming partner brings with them clients. Those clients are making payments existing prior to them joining the partnership. Those incoming payments can be used to satisfy prior debt of the partnership. Again, dissociating partner. A dissociating partner does retain liability for future debts until actual notice is given to creditors that they are dissociating, or 90 days after filing a notice of dissociation to the state. So essentially, the dissociating partner remains liable until people have notice that they are no longer associated with the partnership. And liability by Estoppel. This is a person who represents to a third party that a general partnership exists, is liable as if one does exist. Other corporate forms, you have a limited partnership. This is where you have one general partner and one limited partner. The general partner is liable personally for all limited partnership obligations. And general partner is liable personally for all limited partnership obligations, including torts and contracts. And the general partner has the right to manage the limited partnership. The limited partner does not. You have an LLC. It's maybe the most common corporate formation. This is where the members are owners with limited liability, and they can go to piercing the corporate veil. And they have limited liability for debts and obligations of the business, and they have the benefit of personal taxation. It requires an article of organization and operating agreement. Looking at the rights and liabilities between partners. Partners are fiduciaries. They owe a duty of loyalty, no self-dealing, usurping corporate opportunities, or secret profits. A remedy where there is a violation of these duties is an action for accounting. You can recover losses caused by a breach and disgorge profits. Looking at the rights and liabilities between partners in the partnership in regards to partnership property. You may not transfer specific partnership assets without partnership authority. An example would be land, leases, or equipment. Partnership property, and looking at personal property, you can transfer profits and or surplus owned by an individual partner to third party, again, but you cannot transfer partnership owned property. In regards to partnership property, general partners have a right to share in management of the property but may not transfer. And looking at management of the property, again, under rights and liabilities between partners and management of the partnership, each partner is entitled to equal control and vote absent agreement, or where it is a limited partnership. The general partner has that control. That's salary and rights and liabilities between partners. Absent agreement, partners do not get a salary unless they are winding up. In regards to profit and losses, absent an agreement, profits are shared equally, losses are shared like profits. Looking at partnership dissolution. Dissolution begins the end of a partnership. If it's at will, dissolution is automatic upon notice of express will of any one general partner to dissociate. Not at will dissolution occurs upon the happening of an event specified in the agreement or by a majority vote of partners to dissolve within 90 days of dissociation of a single partner. Now, winding up is the time between dissolution agreement and termination. Termination is the actual end of the partnership. Partnership dissolution and compensation. Partners get compensation during winding up. General partners retain liability on transactions entered into to wind up old business with creditors. General partners still retain liability on new transactions until actual notice of dissolution is given to creditors or 90 days after filing a statement of dissolution. We're going to have priority, partnership dissolution and priority of creditors. The first creditors are outside non-partner trade creditors and inside partners who loaned money to the partnership. After these creditors, you have capital contribution by partners. They are second, and then the remainder is profits shared equally absent agreement. Losses are shared like profits, and that completes our review of agency and partnership for the exam.